Milliken v. Bradley, 418 U.S. 717 from 1974. Class action is when a number of people who have been hurt by the same person or institution get together and are recognized as a class and then file a lawsuit. So a class of Black Detroit students and parents filed a class action suit against the Detroit Education Board and Michigan state officials, alleging de jure, which means intentional, forced segregation in Detroit's public schools. The district court found that the state and local officials had deliberately maintained segregated schools, concluding that only remedies within the city of Detroit would be ineffective since the city was majority Black and the surrounding suburbs were majority white. There were 53 suburbs that were pulled into this to ensure that no school would be racially imbalanced compared to the broader area. The Sixth Circuit affirmed the need for metro-wide approach. They appealed to the Supreme Court. The Supreme Court faced a changed political landscape. Richard Nixon actually appointed 4 Supreme Court justices. So now this case was going to a much more conservative body, less sympathetic to broader desegregation remedies. The central question was whether a federal court could impose a cross-district desegregation remedy that included suburban school districts when those districts in particular had not been proven to have engaged in intentional discrimination. The Supreme Court held 5-4, held that cross-district remedies were impermissible unless there was proof that other districts or the state had engaged in inter-district constitutional violations, or that Detroit's segregation produced inter-district effects. Claim and standing requirements. The plaintiff's injury in fact alleged that Detroit public schools were racially segregated as a result of intentional state and local policies, and they sought implementation of a plan to dismantle segregation and establish unitary non-racial school systems. This is consistent with Brown v. Board of Education. The cause or causation. Plaintiffs tied Detroit segregation directly to discriminatory actions of state and city officials, including housing, redlining, and attendance policies that entrenched racial separation. What was the redress or the remedy they were looking for? Because it was a class action, the plaintiffs sought system-wide relief, not just for one family. The proposed remedy was a metropolitan-wide desegregation plan, including busing across district lines, to achieve a racial balance that a Detroit-only remedy could not. Arguments of the plaintiff. Plaintiff said the state and local officials, including Governor William McKillen and Superintendent Bradley, had deliberately maintained segregated schools. They said a Detroit-only desegregation plan was ineffective because racial segregation was reinforced by housing patterns and suburban boundary lines. Effective remedies had to include the suburban district, since segregation could not be dismantled within Detroit alone. What did they cite as their proof? Well, the 14th Amendment Equal Protection Clause, one of our core constitutional bases. Brown v. Board Education, 1954 and 1955 principles, dismantling segregated dual school systems through equitable remedies. Arguments of the defendant, the state of Michigan and the suburban district. No proof of suburban wrongdoing. Suburban school districts argued they had not engaged in any intentional de jure segregation, so they could not be forced into a remedy. District autonomy. Defendants stressed that school district boundaries are legally significant and should not be overridden unless they were drawn or used with discriminatory intent. Local control tradition. Citing the long American tradition of local control of education, they argue that forcing suburban districts into a metropolitan plan would undermine this principle. Scope of violation versus the remedy. So they're saying that the violation was really small and the remedy was really big. They claim that Detroit-only violations could not justify a region-wide remedy. The court should limit desegregation orders to the boundaries where the violations were proven, and that is in Detroit itself. Equal protection compliance. Suburban districts maintained they were already operating on a racially neutral basis, and thus were in compliance with the 14th Amendment's Equal Protection Clause. Federalism concern. Defendants warned that broad metropolitan remedies would improperly expand federal judicial power into the local and state control of schools. All the key cases, Brown v. Board of Education 1 and 2, segregation is unconstitutional. Courts can use flexible remedies to dismantle it. Green v. County School Board, 1968. School boards have an affirmative duty to eliminate segregation root and branch. Swan v. McCharlotte-Muhlenberg, 1971. Remedies must match the scope of the violations, authorized strong intra-district remedies like busing. Keyes v. School District Number 1, 1973. Proof of intent triggers broad remedial authority, but only within the proven system. Both Wright v. Council of Emporia, 1972, and U.S. v. Scotland Neck, 1972, allowed altering district lines when changes undermined desegregation. San Antonio Independent School District versus Rodriguez, 1973, held that education is not a fundamental right and upheld school funding disparities based on property taxes. Relevance, Rodriguez and Milliken together weakened Brown's promise by permitting both unequal funding and continued segregation. The Supreme Court's decision, majority was Justice Berger, joined by Stewart, Blackmun, and Powell and Rehnquist. Remedies must be limited to the violation proven. Since there's no evidence that suburban districts engaged in intentional segregation, they could not be forced into the plan. Sundowntown emphasized local control of schools as a core American tradition. There was a concurrency with Justice Stewart, who agreed that district lines could not be overridden, but stressed that if there were proof those lines were drawn or used with segregative intent, the interdistrict remedy would be appropriate. So Stewart was a little soft on that. The justices who dissented were Justice White, joined by Douglas, Brennan, and Marshall. A Detroit-only remedy would not work. Metro housing and school patterns demanded a regional remedy. District lines should not protect segregation. Justice Marshall wrote his own dissent, joined by Douglas, Brennan, and White. Effective remedies must reflect metropolitan realities. Limiting remedies to Detroit alone gutted Brown and left urban Black students in segregated schools ringed by white suburbs. Later cases that cited Milliken v. Bradley was Milliken 2. On remand, the court upheld Detroit-only remedies that included remedial education programs like reading initiatives and teacher training, and required the state to share costs. This confirmed the court's power to order compensatory education within districts, but reaffirmed the bar on cross-district remedies without proof of inter-district violation. Board of Education v. Dowell, 1991, cited Milliken in holding that federal desegregation orders were not meant to operate forever. Courts could release districts from oversight once they showed good faith compliance and eliminated segregation to the extent possible. They used the Milliken's principle that the remedies must fit the proven violation. Freeman v. Pitts, 1992, expanded upon Dell. Federal courts could withdraw supervision gradually, even if some aspects of segregation remained, as long as the district had complied in other areas. Cited Milliken for the idea that desegregation remedies are limited in scope and time. Missouri v. Jenkins, 1995, concerned Kansas City schools. The court struck down the costly desegregation plan, including salary increases and magnet schools, designed to attract white suburban students into the Black city. Relied on Milliken to emphasize that remedies must be tailored to the constitutional violation and cannot impose obligations on suburban districts without proof of their involvement. Now, this one's interesting. Parents involved in community schools v. Seattle School District Number 1 from 2007 addressed a voluntary school integration plan. The court struck down race-based assignment policies in Seattle and Louisville. Milliken was cited to stress that racial balancing for its own sake is not a permissible goal. Remedies must be tied to constitutional violation. I just want to make sure that I get in court cases from the actual ones we're studying in this unit, instead of, the other court cases are in the Supreme Court themselves, but these are important because we're studying them now, and in a sense, they lead to what these are. But let me begin with Dred Scott v. Sanford from 1856. The story is an enslaved man sued for freedom after living in a free territory. Could he do that in federal court? Well, the rule was that citizenship under the Constitution excluded Black people. The analysis is that the court said Black people had no rights which the white man was bound to respect. Plessy v. Ferguson from 1896. And the question was asked, did segregation violate equal protection? And SCOTUS upheld separate but equal, which led to segregating schools. And in effect, the court legitimized the Jim Crow laws. and segregation was declared constitutional. And then in 1962, there's Meredith v. Fair, where James Meredith fought to integrate the state universities deny entry based on race. And the rule was, does the 14th Amendment require equal access to education? And the answer is yes, it does. So the court forced admission. The conclusion is advanced desegregation of higher education. And of course, the one I'm writing about is Milliken v. Bradley. And I talked about the 14th Amendment.